Ladies and gentlemen, thank you for attending this seminar organized by the Faculty of Law and the CCPL. My name is Fu Hualin. I'm the Dean of the Faculty of Law. We have organized many events in the past few years, and due to the COVID constraints, they were mostly limited to online events. It is very delightful to see many of you here, mostly mask off. We continue to pay attention to important legal developments relating to national security law, broadly defined to include the NSL, the crimes, and other related legal issues. In the past, we organized a number of seminars on the NSL in the early days of its implementation. We also organized seminars on foreign judges, on the crime of sedition. Today, we are hosting a seminar on another important topic. National security is a core interest of China, and Hong Kong, of course, is duty-bound to enhance its legal protection. The NSL has been in operation for nearly 3 years, and the Standing Committee of the National People's Congress has given its first interpretation. It is important to analyze its impact and implication and ways in which Hong Kong law can best respond to the constitutional requirement. On today's topic, it is extraordinary to have foreign lawyers to practice domestic law in another nation state. It is nearly unprecedented to have foreign qualified lawyers to practice national security law in another country. But Hong Kong is a special place and deserves special attention. Today, we'll discuss the amendment of the Legal Practitioners Ordinance. It is a very timely event as the government has just tabled the Legal Practitioners Amendment Bill 2023. Our discussion today will go beyond the bill. Any discussion on this matter would necessarily involve the broader context of the interpretation of the national security law and Hong Kong government's duty to implement Article 23, as well as the impact on the individual cases before the courts. Our purpose is to build a platform for rational, constructive discussion. Now the pandemic is over. Let's resume the role we used to play in promoting academic discussion on important legal matters facing us. Thank you for your attention.
Thank you very much, Dean Fu. Let me join the Dean in welcoming you all to this event organized by the Center for Comparative and Public Law at the University of Hong Kong. I'm Cora Chan, Associate Professor at the Faculty of Hong Kong U, Faculty of Law of Hong Kong U, and I'll be chairing this event. We're extremely honored to have 4 distinguished speakers today. Professor Albert Chan, Cheng Lan Yu, Professor and Chair of Constitutional Law at the Faculty of Law of Hong Kong U. Mr. Victor Dawes, SC, Chairman of the Hong Kong Bar Association. Mr. Alan Hu, SC, Chairman of the Basic Law Institute, and Professor Simon Young from the Faculty of Law of Hong Kong U. Let's begin by inviting Professor Chan to address us.
Thank you, Cora. Good evening, ladies and gentlemen. As the first speaker in this seminar, I'll speak on the topic of the NPCSC interpretation of the NSL and the Legal Practitioners Amendment Bill of 2023. I'll mainly talk about the background to this interpretation, in particular the case, the case involving the admission of Mr. Timothy Owen as a barrister in the Lai Chi-ying case. So we begin with the text of the national security law. There is one provision in the law concerning its interpretation, and that is Article 65, which vests the power of interpretation of the law in the NPC Standing Committee. As a national law applied to Hong Kong under Annex 3 to the Basic Law, like other national laws, the NSL is subject to the interpretation of the NPC Standing Committee, because as we all know, under the PRC Constitution, the Standing Committee of the NPC has the power to interpret all laws of the PRC, laws made by the NPC itself and laws made by the NPC Standing Committee. This provision in Article 65 can be compared with Article 158 of the Basic Law on the interpretation of the Basic Law. As we all know, this article also vests the power of interpretation of the Basic Law in the NPC Standing Committee. But there is also an express provision empowering the Hong Kong courts to interpret the Basic Law while adjudicating cases, subject to the duty of the Court of Final Appeal to refer certain provisions of the Basic Law, namely those relating to the relationship between Hong Kong, SAR, and the central authorities, or the responsibilities of the central authorities, to the NPCSC for interpretation before final adjudication. There is no provision in the NSL itself providing for any reference by the Hong Kong courts to the NPCSC for interpretation. So presumably, the NPCSC can exercise its power of interpretation at any time, irrespective of whether there is any case being litigated before the Hong Kong court. Now, in the case of the Basic Law, as we all know, the Chief Executive of the Hong Kong SAR has, on at least 2 occasions, taken the initiative to refer relevant Basic Law provisions to the NPC Standing Committee for interpretation. Now, this is what has happened recently after the courts have decided the case on the admission of Mr. Timothy Owen in the Lai Chi-ying case. The Chief Executive, as I'll mention in a minute, actually submitted a report to the central authorities, which led to the Standing Committee exercising its power under Article 65 of the NSL to interpret it. Well, my own view is that even though Article 65 of the NSL vests the power of interpretation in the NPCSC and does not contain any provision similar to Article 158 of the Basic Law empowering the Hong Kong courts to interpret the law while adjudicating cases, in practice, the Hong Kong courts do have the power to interpret the NSL while adjudicating cases, and they have actually done that in a number of cases which they have already tried. Because as we all know, before the court applies any law to any case, it may have to interpret the relevant law. If there's any ambiguity in the relevant law, any lack of clarity as to how it will apply in a particular case, the court will have to interpret the relevant law or the relevant legal provision. So I think even though the text of Article 65 of the NSL differs from Article 158 of the Basic Law, I think the practical effect is the same, namely that the Hong Kong courts do have the power to interpret the NSL subject to the overriding authority of the Standing Committee to issue an interpretation of the law at any time. So let me turn to the case concerning the admission of Timothy Owen, KC, which was a case decided under Section 27 of the Legal Practitioners Ordinance. So this case was not decided under the national security law, although it concerns the prosecution of Lai Chi-ying under the national security law. Section 27 of the Legal Practitioners Ordinance is a provision about admission to practice as a barrister in Hong Kong. It is actually generally applicable to anyone who seeks to be admitted as a barrister in Hong Kong. So, for example, our students who have finished the PCLL and who want to do pupillage and become a barrister will have to get admitted as a barrister under Section 27, subsection 1 of the Legal Practitioners Ordinance. And this student will be admitted if he or she meets the qualification and residential requirements specified in Section 27. The same section contains subsection 4, which provides that the court may admit a foreign lawyer as a barrister for the purpose of any particular case, notwithstanding that he or she does not satisfy the requirements for admission under Section 27, subsection 1. So that is the provision which the court applied in the Timothy Owen case. This is the data provided by the government in a paper recently submitted to the Legislative Council on the proposed amendments to the Legal Practitioners Ordinance. So it shows the number of applications for admission under Section 27(4) in recent years, and including a number of civil cases, including judicial review cases and criminal cases in which such admission was sought. So how does the court decide whether to admit a foreign lawyer for the purpose of Section 27, subsection 4? According to the case law, the public interest is the primary consideration of the court. It is for the court to decide whether it is in the public interest that a particular foreign lawyer be admitted under Section 24, Section 27, subsection 4. And there are certain relevant considerations which the court will take into account in making this decision, in exercising its discretion as to whether to admit a foreign lawyer or not. The court will consider the level of court in which the overseas counsel will appear. So in most of the cases concerned, the application is for admission of the overseas counsel in a very high court, such as the Court of Final Appeal. The importance of the legal issues in the case, that is, its importance to Hong Kong SEL jurisprudence is another factor. The more important the legal issues concerned, the more likely that the court will exercise its discretion to admit the foreign lawyer. The court will also consider whether the case is complex and difficult. So the more complex or difficult the case is, the more likely is it that the court will admit the foreign lawyer. The court will consider whether the overseas counsel can make a significant contribution to the case by reason of his or her expertise and experience, and also the availability of suitable local counsel. So these factors are relevant, and I think it is easy to understand why they are relevant. In the Timothy Owen case, the Chief Judge, Justice Poon of the High Court, was the judge who dealt with the original application for admission of Mr. Timothy Owen. The case was argued and decided on the basis of the principles and considerations which I've just mentioned. And in reaching its decision, the court pointed out that the Lai Ching case was the first prosecution under Article 29, subsection 4 of the NSL, involving collusion of foreign forces to endanger national security, and that the case also concerned sections 9 and 10 of the Crimes Ordinance relating to sedition. And on these legal provisions or legal issues, the foreign jurisprudence on balancing human rights against national security would be relevant. That's one important point made by the Chief Judge when he decided to admit Mr. Timothy Owen to this case. It is believed that Mr. Owen can make a valuable contribution to the case, given the nature of the case and the issues it involved. The Department of Justice, who opposed the admission, appealed the case to the Court of Appeal. The Court of Appeal pointed out that the appellate court would not easily overturn the judge's decision under Section 27, subsection 4. If the judge had made a decision on whether the admission is in the public interest after taking into account and balancing relevant considerations, the appellate court will not intervene unless three conditions or one of the three conditions has been satisfied. As I mentioned here, the judge has misdirected himself with regard to the applicable principles, the judge has not taken into account relevant considerations or has taken into account irrelevant considerations, and thirdly, the judge's decision is plainly wrong. So on the appeal, the government argued on point number 2, namely that the judge has not taken into account the unique context of the NSL and the circumstances of its enactment. But the Court of Appeal held that the judge had actually already taken this into account, and there was no reason why the appellate court would need to intervene. The government then applied to the Court of Appeal for leave to appeal to the CFA, and in this application, the government put forward a new argument, which was not mentioned in the 2 previous hearings, namely that the objectives and the overall design of the NSL, including its provisions against collusion with foreign forces to endanger national security and potential issues of state secrets and lawyers' confidentiality obligations, are such that the ad hoc admission of overseas counsel should be refused, save in exceptional circumstances in national security cases. But the Court of Appeal was not persuaded to give leave to appeal. It pointed out that there was no issue of state secrets in the Lai Ching case, and it applied the principles decided in Flywin and Strong Associates. I think there's a typo. It's not 2022. I think it's 2002. According to that case, and the principles concern new points which were not argued in the lower courts could not and should not be raised at the stage of appeal to the Court of Final Appeal. The government then applied to the CFA itself for leave to appeal to the CFA, and the appeal committee of the CFA rejected this application. And I've quoted here paragraphs 27 and 32 of the judgment, which summarized the court's decision to reject the application for leave to appeal. Basically, the court continued to apply the Flywin principle. So on the same day as the day the CFA rendered its decision, the CAE submitted a report to the Central People's Government, and it was stated by the chief executive that the central government actually, on the day before, requested the CE to provide a report under Article 11 of the NSL on the implementation of the NSL in Hong Kong. The CE in the report recommended that the NPC Standing Committee should interpret the NSL to clarify the issue of whether an overseas lawyer may participate in the handling of cases concerning national security. So here you can see the English translation of the interpretation, and there is this Chinese original, which there's this comparative table compiled by Professor Wong of Peking University, which highlighted the additional language in the interpretation, which is not in the NSL itself. The interpretation is of Articles 14 and 47 of the NSL. And you can see here on the left-hand side, Article 14 and Article 47. And on the right-hand side, we have highlighted by underline and bold characters those words in interpretation which are not in the text of Articles 14 and 47 itself. Actually, time is up, but I think I would take maybe two more minutes to finish. So I comment on the interpretation as follows. The interpretation does not directly reply to the question posed by the CE. The approach adopted by the interpretation is institutional, jurisdictional, and procedural. Its focus is on the jurisdiction of the CE under Article 47 and the powers of the NS Committee under Article 14. In particular, the interpretation provides that the issue of whether foreign lawyers may participate in a national security case is an issue which should have been referred for the chief executive to certify under Article 47 of the basic of the NSL, and in the absence of such a certificate from the CE, the National Security Committee should deal with the matter under Article 14. So I think the possible considerations that underlie this approach adopted by the NPCSC include the following. First, to avoid frequent substantive interpretations of ambiguous provisions of the NSL or frequent interpretations of the NSL to supplement its provisions. And secondly, to minimize any adverse effect on the Hong Kong SCR judiciary in this particular interpretation, and to maintain local and international confidence in it. There are several issues which arise from interpretation, which are listed here. For example, what exactly are the circumstances in which Article 47 will be used? What is the procedure for invoking Article 47? What is a CE certificate under Article 47? What can it state? What should be the content of such a certificate? To what extent would the court give effect to the certificate? And as regards Article 14, issues include what is the scope of the NS Committee's power? Does the NS Committee has any legislative power or judicial power? Or does it have some executive power? Or does it only have some policy-making power similar to those of the Executive Council under the Basic Law? If we have time in the question and answer period, I can state my views on some of these issues. So as we know, after interpretation, the NS Committee actually met on the 11th of January 2023, but it did not do anything which settled the issue. It only said that, well, it supported an amendment of the legal practitioner's ordinance to deal with the issues which arose from the interpretation. And as we know, just a few days ago, the Legal Practitioners Amendment Bill 2023 was gazetted. And I think the other speakers today will speak in great detail about this bill. I have in this PPT highlighted a few issues arising from the bill, but because of time constraint, I will not be talking about these issues here. So that's all for my presentation. Thank you.
Thank you very much, Albert. May we now invite Mr. Alan Hu SC to address us. Mr. Hu, please.
Thank you for coming this afternoon. It's good to have a face-to-face session after such a long lockdown in Hong Kong. I also want to thank the Dean, Fu Waling, for organizing this seminar. It's the second one I've participated. The last one was on the Court of Final Appeal judges being prevented from coming by the then British Foreign Office. These seminars, I think, on the rule of law in Hong Kong are very important platforms for the university law faculties to better understand developments in the rule of law and the basic law as it is happening, and the outside interest, obviously, that there is in it. On today's topic, I've told the Dean and Cora that I'm concentrating really on the central government's approach to national security in Hong Kong. I was part of the two sessions in 2020 that passed the national security legislation in the MPC. I think that a lot of attention has been paid to the enactment of the 4 offenses in 2020 by the MPC, but not a very in-depth examination of what they were doing in the MPC committee, standing committee, that decided why 4 offenses. Article 23 sets out about 7 or 8. And is this something new? Is this just an order of the National People's Congress Standing Committee to include these enactments under Annex 3 for Hong Kong? But it's specially written. It's not extending the mainland criminal law, which has all these offenses. All of them, they have it, except the sentences are much higher. They can simply extend it to Hong Kong. Let me ask one question first. Which country in the world that has separate legal systems, like China and the SAR here, has national security legislation which is not uniform throughout the country, despite your different systems? Good example is Canada. Starts with Quebec as the sovereign entity, French, continental law, and then the British common law took over. The rest of British Columbia, all the other provinces became the sovereign entity. But throughout Canada, is there just a different set of national security legislation for Quebec under their continental system, expressed in French, mindful of French culture? No. Common sense dictates it must be the one set. So something I wish to remind everybody here, that in 1989, the Hong Kong Bar Association did a great service for Hong Kong. It argued with the Foreign Ministry of England. Sir Geoffrey Howe came to Hong Kong. The bar, Dennis Chan, myself, Daniel Fung, all met him, expressed one view: not to have mainland national security legislation simply adopted wholesale and applied to Hong Kong. At that time, everybody thought we were crazy. How would they ever say yes? There's no basis for it anywhere in the world. Why do you say that Hong Kong as an SAR should be treated specially from the other autonomous regions, from the other provinces, from the special cities, all these different types of regions in China that constitute the whole territory of China? We're just 2 SARs amongst the other provinces and special cities and other autonomous regions. We have highest autonomy. So why would they allow it? And I remember Dennis Cheng has a very healthy attitude. What have we got to lose by asking? And we did. And we also went to London to ask. And we got it. Article 23. What are the magical words in Article 23? To enact national security laws, quote, on its own. What does that signify? Under a common law framework, under common law jurisprudence, something that we in Hong Kong are familiar with. Right? This is where the system that we grew up with, that we're familiar with, they recognize that. I like to point out, after my 20 years on the CPPCC, I must say one thing with the central government. They have credibility and they're honest with how they approach Hong Kong. Right? Their approach has always been a minimal interference into Hong Kong. Right? They say that when I'm there having 2 sessions, they say, why are you so obsessed with us being always dealing with Hong Kong every day? When we get up, it's Hong Kong. No, that's not the first issue. Plenty of other issues central government deals with. We just wish Hong Kong would get on, right? Prosperous, stable, international city. And they love the common law. They do. It's repeated even in 2 sessions this time. Alien to them, yes. And did we enact our legislation on our own? Given the opportunity to do so. Did we? In 22 years, we failed under Mr. Tung. How difficult is national security legislation? As a criminal practitioner, you look at the Bible of practitioners, Archbold. We have a Hong Kong edition. Look at the English edition. Offenses against the state, capital offenses. First category, very simple. Every country have roughly the same definition of treason, sedition, right? Dealing with foreign agents, state secrets. The thing is the jurisprudence behind it. Procedural justice, right? Common law. Beyond reasonable doubt. Open justice, right? They could have exported the whole mainland part to us after 2019 without a whimper because of the situation in Hong Kong. And also, it saddens me because I was part of the celebrations for the Hong Kong Law Faculty 50 years in 2019. Professor Raymond Wax, leading South African jurist, came from England. Wesley Smith came up from Australia. Did it happen? No. I have to babysit both of them. Can't get into the campus. Right? It's a breakdown, let's call it. Rioting? Does it compare the storming of Lechco here with the storming of Capitol Hill in America? Mass protests? I was in England in 2019. A lot of mass protests for the Extinction Rebellion. They want to go to Westminster. They want to go, no, just Trafalgar Square. Same legislation, Public Order Act. We have the Public Order Ordinance. Identical. And they are amending it in England when I was there. They want bail more difficult, repeat it. They want more draconian powers under the Public Order Act. Put it in perspective. Sedition. Those who stormed Capitol Hill been branded by the US Attorney General as seditious conspiracy and insurrection. Why are there double standards? The judges who sit in Hong Kong are the same before the handover and after the handover. There's been no import of new judges. It's all under the scrutiny of the Chief Justice and the Judicial Services Commission. It's open justice in Hong Kong. Lord Sumption, Neuberger, these are heavyweights from England. They come and sit, don't just sit in our CFA. They look at the judicial landscape in Hong Kong. Everything in Hong Kong is open. This is not North Korea. And then in 2019, wow, I thought, going back to the MPC in 2020 in March, I'm waiting for it. Yep, national security legislation is already decided. But then, to me, the important part is minimal action. Only those which the situation in Hong Kong warrants. And what are they? Cessation, right? Take down the national emblem, take down the national flag. Let me here just give you one example of restraint by the central government. If you try to take down the American flag in the US consulate in Garden Road, what do you think will happen? There are armed US Marines inside. Don't you think they have to defend their flag? When the Chinese flag was taken down from the central government's liaison office, right, trampled on, some say feces, smeared on, destroyed the national emblem, did the PLA come out to defend the flag on your own territory? Is that not restraint? I've been told I've only got 5 minutes, but that's good because I'm not very used to unpaid speech. Now, what I want to emphasize, very important about the enactment of the national security legislation, was that's only one part of what the National MPC Standing Committee did. They did two things in their decision. One is to say, wow, you need the laws. You won't do it, we will enact it now for you now, but not using the mainland offenses. Right? But the second thing they said was that, quote, the Hong Kong SAR must complete the national security legislation stipulated in Article 23 of the Basic Law at an earlier date. Right? So what I'm saying is these four offenses are crafted under Article 23, not from the mainland laws. It's laws for you. You continue the work with the remainder, like treason, right? And the other, sedition, theft of state secrets, all that is still left out in the open, ban of foreign agents. You do it. But what I'm saying is that at the end of that will be a holistic piece of legislation that will incorporate both of them, that will define procedure, for example, procedural justice, open justice, a lot of things. It's not just Owen coming to Hong Kong. What about the examination of evidence? No point having a London silk or a Hong Kong silk. Well, are you going to see the evidence? Or is the judge going to see and we get a summary? What about the witness? His identity is bound to be protected. Do I get the scope of cross-examination like I do in normal cases? Or are there restrictions? A host of things that needs to be properly dealt with. And you don't have to reinvent the wheel. As I say, offenses against the state exist throughout the common law world. Take anyone that you like as a comparable standard to compare. And don't just bring down the edifice in Hong Kong. That's what I'm concerned with. That foreign countries think that Hong Kong is already not a ship that's sinking. It's already sunk. Right? And I think that's not fair because we need procedural justice too. A right to be heard before the US Congress, before the House of Commons Foreign Affairs Select Committee. Why always people from one particular viewpoint? Don't you like to have a balanced viewpoint? And the other thing I'll end with saying is that the emphasis should be on the present government's job in completing Article 23 in a holistic way. And I'm encouraged to see that our present Secretary of Justice says he is considering and studying other common law jurisdictions, national security legislation. So we're still in the common law world. And one thing I talk about Tim Owen, I take the bar, so position of objecting to his admission. Why? I can't see why a trial by Chinese judges with Chinese witnesses, with Chinese defendants, have all to be translated in English because of a London silk. Does it make sense? If it's more effective, so be it. He gets it. But the point I wish to make about this bill is that this is LPO. It deals with the right of audience, qualification. The actual control is in immigration, whether they give you a work permit or not. And if the work connects with national security sensitivity, the filter is there. So this actually is just a right of audience backstop. The focus should be on Article 23 when it's being presented. My 5 minutes are up. Thank you all for your patience.
Thank you very much, Mr. Hu. You're right on time. Thank you. May we now invite Professor Simon Young to address us. Simon, thank you.
Hey, thank you, Cora, and good evening, ladies and gentlemen. I echo the Dean's welcome. Welcome back to the faculty. Let me get my PowerPoint slides set up. I'm going to touch upon three specific areas in relation to tonight's topic. And given the time that I've been allotted, it's going to be a very brief discussion of each of the topics. So firstly, the issue of equality of arms. And I think most people know that this mechanism of ad hoc admission of overseas counsel applies, of course, in criminal cases for all parties, so both defense and prosecution. And we have many examples of the prosecution seeking to have overseas counsel admitted, and the scheme applies equally and evenly to counsel irrespective of who's making the application. And here's a very prominent case involving former Chief Secretary of Administration, who was on trial in a very infamous corruption case. And Mr. David Perry represented the Department of Justice, HKSAR, in this prosecution. He was also counsel in the Donald Tsang prosecution as well. And notice, of course, that there are overseas counsel on both sides. And that's very important. I'll highlight that again later on. And of course, people remember the Congo case, again, a case of great state interest and concern. And you see overseas counsel for almost all the parties. For the Department of Justice, who was intervener in this case, they had Professor Von Low from Oxford advising them in this case. So you see, it is a mechanism that is used in very high-profile cases and has had a long sort of history since the handover. Now, the question that I'm concerned with is whether the bill maintains an equality of arms. I'll come to that in a moment. There is one concern that I want to raise, having looked at the substance of the bill in this regard. Now, in case you haven't studied the bill yet, it's relatively short. It proposes basically to add 6 new sections to the Legal Practitioners Ordinance in and around that provision for admitting overseas counsel. Most of the provisions in the bill are procedural, but at the heart of the proposals is this substantive section, which is basically the criteria for the issuance of the certificate by the chief executive. And it's this provision that we need to focus on to assess this possible concern that this certificate mechanism might be applied across the board, basically excluding all foreign counsel. Is that going to be the case? Well, let's look carefully at what the criteria says. The starting rule, of course, is basically a rule that keeps out overseas counsel. So a person must not be admitted if it is a case concerning national security, unless there is exceptional circumstances. So what are those exceptional circumstances? And they're in subsection 2, and there's 2 parts to the exceptional circumstances. The chief executive has sufficient grounds for believing that the person's practicing or acting as a barrister for the case, A, does not involve national security, or B, would not be contrary to the interests of national security. Right? And I highlight the sort of disjunctive, the or. So it's one or the other. So if A or B applies, then that could be the basis for the issuance of a certificate that allows, so it's an exceptional circumstance that allows the Overseas Council to be admitted. Now, I think I can understand the reasoning for why it's disjunctive, because if it was not, or if you didn't have the second condition, then what it's saying is that, well, if it involves national security, basically every case that involves a charge of national security, criminal charge of national, then there would be no certificate. There would be no exceptional circumstance. And that would be basically a blanket ban. So what this contemplates is that the case might involve national security, but there is no risk, right? It's not contrary to the interests of national security, and you can still be allowed to come in, right? That's why I think they've had the two parts here. Now, fine. Now, my concern is how this might apply differently to defense counsel being admitted and counsel for the prosecution, right? Because if you look at, let's say, someone that the HKSAR is seeking to be admitted, then you can imagine a case where, of course, it involves national security. So the first condition would not apply as an exceptional circumstance because it involves national security. But it would not be contrary to the interests of national security. Well, I could imagine maybe the government would argue, well, this counsel is trying to uphold national security because he's representing the government, right? It's a case where the effect of the case is to actually uphold national security. His service here would not actually be contrary to the interests of national security. And that could be then a ground of exceptional circumstances for admission, right? Now, of course, mind you, I think this concern is perhaps more theoretical than real. Because if you look at the practice of the Department of Justice, in the past, I understand there's a fairly well-established practice that they would only seek the admission of foreign counsel if the defense sought foreign counsel. And so it's unlikely that they would initiate on their own if the defense did not. Otherwise, there would, I think, be a real concern of inequality of arms. And perhaps we might still have to look at the discretion. Ultimately, it's a question of discretion in the court as to whether or not the individual should be admitted. So that's the first point. Now I want to turn to the second point, which is the concern about the right to choose one's own lawyer. And for some of you who are familiar with Article 35, you will notice that the language of Article 35 provides for a number of rights, and it doesn't simply say that you have a right to a lawyer, or you should have a right to a lawyer for the timely protection of your rights, but it actually uses the word choice of lawyers. And so naturally, one might think that based on just the plain language here, this has some significance on what we're talking about, because what we're talking about denies someone's choice, Mr. Lai's choice of a lawyer. And the question would naturally be, well, is this right engaged? And should we be focusing on this right? Now those familiar with the jurisprudence around this area will probably know that it's probably not relevant, or it's not engaged, partly because of the way in which our courts have interpreted this right. And it's been interpreted in a very narrow way. here's a couple of cases. This case in the Court of Appeal concerned Dr. Yip K. Low, who appeared for disciplinary proceedings before the medical council. And on the first day of the hearing, he didn't have a lawyer, and he wanted an adjournment to have an opportunity to retain a lawyer. And the council, or the disciplinary panel, refused. And they went ahead and then found him guilty and then suspended him for 3 years. So he appealed this procedural irregularity and was successful. And in the course of reaching that conclusion, the court, Justice Cheng, refers to Article 35 and says that it is not concerned with the provision of free legal service by the government. It also does not enable the litigant to insist to have a particular lawyer, even though that lawyer may not be available to handle the case or is not willing to represent him. Now, stop there for a minute. I can understand, if basically it's simply a case where the lawyer, due to his or her schedule, is unavailable, and it's no fault of the government or the law. But one might think that if it was as an effect or a consequence of a law, then maybe you might think about this differently. Now, when we come to this part, he talks about, well, Article 35, the fundamental requirement is to ensure that the litigant is given an opportunity to seek legal representation. Now, I would comment here, is it just an opportunity, or is it more? Because the language of 35 is choice, right? Choice. Where's the choice here? In practical terms, it means that the court should grant an adjournment when it is asked by a litigant in person, so that he may find a lawyer to represent him. In such a case, if an adjournment is refused, I fail to see how the substance and the spirit of Article 35 can ever be implemented. The rights given by Article 35 can only be exercised if the litigant is given a chance to find a lawyer before the hearing begins. Now, that's fine. I accept that. That's correct. But what he's really just talking about is the chance to have a lawyer. But I would say that Article 35 seems to go beyond that. It's not just about a chance, but it's about a choice, right? So where's the choice? Now, we come to the second case, which is more recent. And this is actually in the proper context that we're talking about, because it's about the admission of an overseas lawyer to represent the individual. Now, what's special about this case is that the client had all along had a solicitor advocate representing them. And as the case was going to be taken forwards, it was hoped that you could have the overseas counsel together with a solicitor advocate, right? And the Court of Appeal and the lower court said no, it couldn't just be like that, because there's a well-established practice that if we admit overseas counsel, that there has to be a local barrister, junior barrister, that is also instructed in the case. So what that would mean is effectively you'd have to pay for another lawyer, the overseas lawyer, the Hong Kong junior barrister, and if you wanted to, the solicitor advocate. And the question is whether that condition to have the local junior was unconstitutional on this issue. And here we have further commentary about Article 35. And the Court of Appeal says that the judge considered the reliance on Article 35 misplaced, as this provision does not provide a constitutional guarantee to have litigation conducted by counsel of one's party's choice. Okay, well, one would have thought that the wording of 35 suggests differently. The judge is clearly right. The choice of lawyers referred to in Article 35 means no more than that a litigant is free to choose his counsel from those available to represent him. So now we come to choice. So this is a development telling us that there is an element of choice here, but it's only from those who are available to represent him. Now, I think the next sentence goes too far. He has no right to insist on being represented by a lawyer who does not have a general right to practice in Hong Kong. Why I say that is because if it is ultimately about the choice from those available to represent him, one can imagine a situation where it's not unimaginable. Maybe there really isn't a lot of choice of counsel who are willing, able to take the case. And so the availability is very minimal. And if it is possible that the defendant would want to have overseas counsel to represent them, then I could see Article 35 being engaged. So I wouldn't simply write it off that this is completely irrelevant or a dead letter in these types of cases. The question then, of course, is it relevant to what we're talking about now, given what was said by the Court of Final Appeal in the Lai Chi-ying case, that you cannot challenge constitutionally review decisions of the Standing Committee and the National People's Congress. Well, one might say that the challenge would be directed at Hong Kong legislation, which of course is something that you could challenge in theory. Finally, and I know I'm running out of time, I come to the very important topic of the scope of the CE's certificate power. And I remember not too long ago being on this very stage expressing, I think it was just in 2020, great concern about the possible width of Article 47. Now, this whole episode, I think, has given us some more insight about the possible breadth of Article 47. Not a lot of clarity, but some clarity. But I also find that comparing it to Article 19.3 of our basic law is a useful exercise to see the scope of 47. And here I've done a comparison because the blue text are things that are different, but much of it is similar. And I'm going to refer to them by the number here, Clause 1. Now, this is very important. Clause 1 of Article 19, which deals with acts of state and facts of acts of state, it tells us that the courts of Hong Kong have no jurisdiction over acts of state, such as defense or foreign affairs. That's not in 47. Right? And then, of course, the main criteria is different. 47 is about acts involving national security. 19 is about facts concerning acts of state. Now, finally, Clause 3 has an additional step where the chief executive has to obtain certifying documents from the central government. That makes sense because acts of state naturally deal with matters of state. So the chief executive needs to be in touch with the central government on those things. This is not necessarily the case when it comes to 47. That's why we don't have that mechanism. But what I want to say is this. Once you have a determination as to something that's an act of state under 19, that first clause tells us the consequences. It tells us immediately that the court has no jurisdiction. You've got to back off. But what 47 does not tell us is once you've certified an act involving national security, which is a very broad term, what's the consequence? I mean, the question, well, so what? So what if this act involves national security? Does it mean the court has no jurisdiction? Of course not. Right? The elements of the offense determining the criminal charges are acts of national security. Our courts clearly have jurisdiction to adjudicate upon them. What's the consequence? Well, we don't know. It's different from acts of state where the consequence clearly specified in 19 is no jurisdiction in the court. What we have learned from this episode is that you need to have some kind of implementation, some legislative scheme, this scheme that we have now when you deal with this particular issue that tells you what the consequence is when you certify an act to be involving national security. Right? So this new piece of legislation tells us basically that the court cannot admit this person to as a barrister to practice in Hong Kong. That's specified in the local legislation. What I'm simply saying is that simply this alone may not actually be all that threatening, in that you might need actual implementing legislation on a sort of case-by-case basis to really see the actual effect of 47. My time is up. Thank you very much.
Thank you very much, Simon. May we now invite Mr. Victor Dawes SC to address us.
Yeah, thank you very much. I can't tell you what happened to the Bar Association and what they did in 1989. I was in secondary school. So Alan did all the good work back then. But I want to start off by giving everyone a bit of background and going into a few issues that I've identified in the bill that was just presented to LegCo. First of all, on the role of Overseas Council in general. I believe Albert assured us some statistics. I mean, since 2015, on average, there's been about 7 to 33 applications for admission of Overseas Council every year. Now, the number dropped quite significantly in 2021. That is a year with 7. I think that was primarily because of the difficulty in flying people in. So that is why we've hardly had any overseas silk. And they're predominantly London silks because of the history and the legal system, although we have had Australian silks admitted to argue cases in Hong Kong. Now, I want to start off by saying that there is absolutely no doubt that top overseas lawyers have made very significant contributions to the development of jurisprudence in Hong Kong. I mean, the government was actually one of the biggest fans of top leading counsel, and this is well known in the legal industry. So, in fact, it wasn't quite accurate when Simon said, well, in terms of the quality of arm, the government usually apply when they know the defense is making an application for admissions of overseas counsel. The case of David Perry, who was, who the government tried to get admitted to prosecute Jimmy Lai in the public order prosecution in 2021. I mean, that is a prime example. On that occasion, the bar also opposed, and we failed. So I would actually echo the sentiment of an article that I read a few days ago by Cliff Buddle. I mean, we really can't treat overseas lawyers as spies. I mean, they're not there, they're here to do their jobs. And in appropriate cases, they should be allowed to do their jobs. So I think that should be the starting point. Now, the sentiment, I must say, and the practice all changed because of the national security legislation. Because as I said, the government was a big fan of overseas counsel. The likes of Perry and Panic were practically in Hong Kong every year. Montgomery, of course, Alan reminding me. And the government used these top lawyers in the high-profile cases. But the approach when it comes to national security legislation have noticeably changed. What we're seeing is that not only are they not instructing overseas counsel to prosecute these cases, they're not even breathing the case out. So it is usually handled in-house by prosecutors within the Department of Justice. And in this regard, I would really like to start off by a point that I made in the beginning of the year, during the opening of legal year. Perceived tensions between the imperatives of safeguarding national security and judicial independence. I mean, it is not unique to Hong Kong. And there's a quote that I really like from Sir Jack Basin in a lecture that he delivered in 2008. And he said this: "The consequent tension is an inevitable feature of the relationship between an independent judiciary and the executive. Lord Bingham said the tension is entirely proper, because particularly at times of perceived threats to national security, governments understandably go to the very limit of what they believe to be their lawful powers to protect the public, and the duty of the judge to require that they go no further must be performed if the rule of law is to be observed. Notwithstanding this understandable tension, however, the executive, the legislative, and the judicial branches of the state should show appropriate respect for the different positions occupied by the other branches when fulfilling their respective constitutional roles." Now, the events that took place in 2019 and the subsequent events are known to all of us. And with the change in the dynamics, one can see that the policy of the central government obviously changed. I mean, Alan is in a better position to explain that, and he has given you his view on that. What then followed? We then have the application to admit Mr. Tim Owen. The bar also opposed, on the same basis that we opposed David Perry's application to prosecute in 2021. And in the same vein, I think the court adopted a more liberal attitude. This was then followed by the interpretation. Now, of course, as I've said in the past, that the power should be used sparingly. And this is an occasion that the government decided to use this power. And once it was announced that it was going to be dealt with by local legislation, which is something that we have advocated, we have also made our view known. We actually don't want a complete ban. The reason I think is obvious. I mean, I've actually thought long and hard as to what is better, what is more conducive for rule of law, for administration of justice, for the people of Hong Kong, and for less controversy going ahead. But what I can tell you is that the members of the Bar Council was unanimous in this decision. Every one of us thought there shouldn't be complete ban. Let's have some flexibility. Overseas Council is something, this system is something that we want to preserve even for NSL cases. Now, we know that there's going to be a regime that is going to be somewhat restrictive. I mean, it is to be expected. You won't expect a very liberal regime when it comes to national security these days. But we were glad that the government accepted the view that there shouldn't be a complete ban. A lot of you would have picked up that even in the AJLS panel meeting, there were some legislators who were suggesting that there should really be a complete ban. Why should we let overseas lawyers come in to do NSL cases? We don't have that anywhere else in the world. Well, what I can say is there are many features in our legal system. There are many things about the city that we don't have in other places in the world as well. Hong Kong is unique in many ways. Now, I'm glad that we have a system that would allow the involvement of Overseas Council in appropriate cases for NSL prosecutions and also NSL-related cases. But when one takes a look at the bill and the government's proposal, there are a number of issues that are actually worth discussing. The first question that I get asked a lot is, what is going to happen to Tim Owen? Because the SJ has made it very clear that the legislation is not going to have retrospective effect. So this was something that everybody started asking. And the answer that we got is it will be dealt with by other means. So we'll have to wait and see what happens. As some of you would know, the team representing Mr. Jimmy Lai and same team representing Mr. Owen has taken out an application in the High Court for determination of a number of issues as to whether, for example, the interpretation actually applies to Tim Owen's case. Now, that is something that the court will be hearing. The other thing that I was quite interested in, and it is a question that I asked the Secretary for Justice at LegCo before I saw the bill, is whether the CE's role in what we call the pre-screening process, is that going to be amenable to judicial review? I mean, he's certainly exercising an executive function, and issues like this have actually arisen in other jurisdictions. And there was a recent case that went all the way to the Supreme Court in England, known as our Privacy International versus Investigatory Powers Tribunal. The case is particularly interesting because two questions were answered by the Supreme Court. And the significant one here is whether Section 67(8) of the Regulation of Investigatory Powers Act 2000 oust the supervisory jurisdiction of the High Court to quash a judgment of the Investigatory Powers Tribunal for an area of law. Now, one can really appreciate that the precise question is different because in Privacy International, the question involved the relationship between the High Court and an inferior court of limited statutory jurisdiction. And there's no such dynamics here, of course. But in that case, what the court had to consider was this, because the IPT, the Investigatory Power Tribunal, they actually specializes in national security and intelligence matters, including equipment interference, namely hacking, the use of intrusive power, and phone tapping by law enforcement agencies and public authorities. the tribunal had bespoke rules and procedures, and including closed procedures and the receipt of what would normally be inadmissible evidence. And the subject matter falling under IPT's jurisdiction and its institutional competence is at the very least comparable to the subject matter that the CE is actually dealing with under the bill. You'll be interested to know that both at first instance and in Court of Appeal, the courts upheld the clause that outs the jurisdiction of the court to review the decision of the tribunal. But when the matter went to the Supreme Court by a judgment, a majority judgment, the court actually formed the view that no, all oust clauses, when you ousted the jurisdiction of the court in judicial review, they should be construed very, very narrowly. And in that case, the court formed the view that it should only apply to decisions that are not erroneous in law. Now, whether there's going to be a judicial review of the ouster clause in Section 27F of our legal practitioners ordinance is something that is yet to be seen. But looking at the experience in England, this is certainly an area that would attract attention and I'm sure academic commentary. The other question that we have also asked in LegCo is the scheme that the government is putting forward unduly complex? Is it necessary? Further, what is the SJ's role in pre-screening? I mean, they are supposed to be the one who received the application, and they are supposed to just pass it to the CE. So in the process, the SJ could be wearing a number of different hats because they do have a role to play as guardian of public interest in all overseas admissions proceedings. Now, the SJ assured us that there's going to be the usual firewall because the department are wearing different hats, but this is another matter that we have raised with them. Over the past few months, we have heard a lot of statements from senior government officials, from the Central People's Government, reiterating one country, two systems, reiterating the use of common law. They are actually keen actually for mainland lawyers to learn more about common law. Now, what I would urge the government, and I'm sure this bill will be passed to the central government, is really this. I mean, Hong Kong, as we know, all of us in this room know, we are really a very unique place. Our system is unique. The people here are unique. And we're, of course, used to a high degree of freedom and autonomy. Now, a delicate balance will, of course, have to be struck when we're dealing with matters of national security. And going ahead, we certainly hope that the interests of everyone would be considered and that we'll be able to find a path that is suitable for Hong Kong. I'm sure we'll be answering questions, but that is all I want to say at this point.
Thank you very much, Mr. Dawes, and thank you to all speakers for very thoughtful and stimulating presentations. I would first like to ask if there are any questions from the floor. Okay, we already have one, so yeah.
Thank you. My name is Jeremy. I'm the first-year juris doctoral student, and I want to thank all the speakers on the panel for their very insightful speeches. My question is about concerns judicial independence. So we know that in the Democratic Republic of Congo, #1, the Court of Final Appeal held that in relation to a certificate of fact, so long as the court still has the power to decide the legal consequence of that certificate of fact, the principle of judicial independence is not undermined. But now, according to this amendment bill, it seems that the court will not have the power to decide the legal consequence of a overseas council being certified as a national security risk per se. And if it seems to be contrary to the principle in Congo #1, especially when considering the concept of judicial power in basic law, given the theme of continuity. I think it's I've done some research, and it's arguably possible to interpret the judicial power in basic law to include the power to admit and oversee councils, because that power existed in Hong Kong since 1844 to waive certain requirements in admitting and oversee council. So considering the tradition of this power, considering the principle in Congo, isn't it at least arguable that this bill, if passed and if duly enacted, would be unconstitutional for undermining judicial independence?
Would any of our speakers like to take the question?
Let me state this view. As Albert said, the interpretation sought by the Hong Kong government as to whether UK council should be banned in national security cases was not responded to. I bet you when the interpretation request went, nobody expected them to come back and said nothing. Didn't respond to it. It says, Article 47 is there. You can use it. Certificate. Right? That's why. Right? So the bill, the Secretary of Justice already said, it's not retrospective. So how does it interfere? It's because it respects the court's independence that they say, no, it's not retrospective. So it's a different agency that's dealing with it now. I don't think there should be wait and see. I'm sure the Immigration Department, if there's a certificate under Article 47, it's not going to give the guy a work permit, whether in court or doing some other work that is national security sensitive, right? What the court decided is just that Mr. Owen has a right of audience if you can get past immigration first.
Sure. Albert.
Actually, the question concerns the interpretation of Article 47 of the national security law. As I just said in the presentation, even after the interpretation, there are certain questions arising as to what the CE can say in the certificate issued under Article 47. Now, if you read the literal wording of Article 47, it says that the courts shall obtain a certificate from the CE to certify whether an act involves national security, and the certificate shall be binding on the courts. So on the face of it, a certificate under Article 47 only concerns whether a particular act involves national security. But as Simon just pointed out, actually, under the proposed legislation, the CE is going to certify more than that. So may I refer you to the relevant section in the bill. Simon, do you remember which section is relevant as to what the certificate will say?
27B.
27B?
The criteria. I think it has the criteria.
Section 27B. But the section 27B does not actually refer to the word certificate. Is there? I think there's some provision on what the certificate will say.
Maybe 27D, I think. 27D.
I think, yeah. So both section 27B, AB, and also section 27D is relevant. Yes, particularly section 27D, subsection 1. before making any order as to admission of the foreign lawyer, the court must request and obtain a certificate from the CE under Article 47 on A, whether the persons practicing or acting as a barrister for the case involves national security. So here, the wording is whether the foreign lawyer's participation involves national security. So that repeats the exact wording of Article 47. But then, paragraph B goes one step further to say that the certificate will also address the question of whether the persons practicing or acting as a barrister for the case would be contrary to the interests of national security. So I think Section 27D of the bill actually answers to some extent the question I just posed as to what exactly the certificate issued under 47 may say. So according to Section 27D, the certificate can go further than just saying whether a particular matter involves national security. It can go further to say whether a particular matter is contrary to the interests of national security. So I think that would probably be taken as the proper interpretation of Article 47, so that when Article 47 says that the CE can issue a certificate as to whether an act involves national security, the CE can also state in a certificate as to whether the particular act or matter is contrary to the interests of national security. Now, Article 47 says the certificate shall be binding on the courts. And also, this is also repeated in the text of the interpretation. The text of the interpretation, I think, only reproduces this point, saying that yes, so it doesn't add to Article 47 on the binding effect of the certificate. So basically, the court will be bound by the certificate. So the court will no longer be able to form its own judgment as to whether the admission of the overseas lawyer is contrary to the interests of national security. So in that sense, the court's discretion to admit the foreign barrister under Article 47, Section 47, is now subject to what the CE states in the certificate. So I don't think there's any issue of constitutionality, given what the bill has said and given the text of the interpretation and the likely interpretation of the interpretation. Thank you.
Thank you.
Hi, I'm Anson Wong, barrister. Just to put in a disclaimer, I do not add for Timo Wan or Jimmy Lai or the government. But just out of curiosity, academic curiosity, I would like to ask the speakers, what's your view on whether the new scheme should apply to Mr. Timo Wan Casey's admission? Because as a matter of law, Mr. Timo Wan Casey has already been admitted by the High Court of the Hong Kong, and the judgment of the Chief Judge of the High Court has been affirmed by the Court of Appeal, and then the Appeal Committee of the Court of Final Appeal has refused leave. So theoretically, the Hong Kong government has exhausted all the appeal mechanism. And as the matter now stands, the ad hoc admission of Mr. Timo Wan Casey is still effective. So the million-dollar question is, how can that admission be in any way affected or overturned by the new scheme? And a further question is, following up on what Alan mentioned, the immigration issue, the granting of work permit. So is it really lawful for the immigration department to withhold or refuse a overseas lawyer's work visa when the High Court of Hong Kong has already granted ad hoc admission for that particular lawyer?
I don't think the High Court's decisions got any relevance to the Immigration Department. Who are the parties? I've said the legal practitioners' ordinance to deal with legal practitioners, people who are otherwise not qualified to practice in Hong Kong are allowed to come to, it's called right of audience. It only binds the bar who's objecting to say you can't object. He can practice. Right? Immigration is another matter. It's not binding on the Immigration Department, number one. Number two, as I said, the Secretary of Justice says, we're not touching that. It's not going to be retrospective, right? We respect it. You've allowed him to have right of audience. So if he gets past immigration, he'll be able to appear in the court. But immigration will have its own protocol and discipline in all countries. You think it's easy to get a work permit in America to go and defend somebody or to do legal work that the CIA or the FBI is concerned with? Right? As I say, we're not reinventing the wheel here. Every country has national security legislation. Right? In common law world, they're pretty similar. It's as everybody here says, we just be mindful of the procedural justice, right? The right to be heard, open justice, all that. What's the point of Mr. Owen coming in if he can't see the evidence? If the public can't come in, what's the point? Adds to the credibility. Oh, he's there. But what about the other parts of national security trials? Look at other countries, right? And people in Guantanamo don't even have a trial. Anyway, thank you.
Well, I agree with Alan on the immigration point. I would say a little bit more about it, and I also want to talk about the status of the court's decision on the admission of Mr. Owen. First, I think we should bear in mind that the court's decision in the Owen case was a decision under Section 27(4) of the Legal Practitioners Ordinance. It is not a decision as to the substantive rights and liabilities of litigants, which courts usually decide in other cases litigated before the court, but by applying the law as it stood to certain acts or events that occurred at a particular time. So for those ordinary cases in which the court applied the law as it stood at a particular time to certain acts or events that occurred at that time, for the purpose of determining certain rights and liabilities arising from those acts or events, the question of retroactivity may arise as to whether a subsequent change in the law will affect the court's determination. And of course, usually there's no retroactivity because those events or acts occurred in the past, and the rights and liabilities flowing from those acts or events should be determined by applying the law as it stood at the time. But this is not the nature of a decision of a court under Section 27(4) of the Legal Practitioners Ordinance. As I already said, Section 27(4) is in the same section as Section 27(1), which is the section which deals with the admission of barristers of, say, PCLL graduates from this faculty. So after a student, PCL graduate, has been admitted as a barrister under Section 27(1), it doesn't mean that this person will have an unqualified right to practice forever. The admission is only relevant and effective for the purpose provided for in Section 27. So similarly, any admission of a foreign lawyer under Section 27 for the purpose of a particular case is subject to the law as it stands from time to time. So putting aside the change in the law, as Mr. Allen was just said, the court's decision under Section 27, subsection 4, has no implications whatsoever as to whether Mr. Owen may be admitted by the immigration authorities to enter Hong Kong. Just as if a student of ours is admitted under Section 27, paragraph 1, as a barrister, but the student, but this person is in the UK, he or she cannot rely on his admission under Section 27(1) to insist that he be granted a visa to come to Hong Kong. If he or she is not a Hong Kong permanent resident, the immigration authorities have full right and power not to grant this person a employment visa or admission or permission to enter Hong Kong. So it's the same. I think there may not be full understanding of what actually the court decided in the Owen case. What the court decided in the Owen case is similar to the admission of any barrister under Section 27, paragraph subsection 1. So that deals with the immigration issue. Now, as for the status of the court's decision to admit Mr. Owen under Section 27(4), in my view, the admission is only valid if the trial the trial took place as originally scheduled. So if the admission was approved on day 1, and then the trial took place on day 7, and there was no change in the law in the meantime, of course, the admission would be perfectly valid. But if the law has changed as to admission of foreign lawyers in national security cases, I think it is highly doubtful whether the original admission can still be relied on when the trial of Mr. Jimmy Lai takes place, say, in autumn this year. Of course, this matter will be adjudicated by the court, as has been pointed out. There is an action now pending before the court, which will be dealt with in due course. So I am only offering my own personal views on the matter.
Thank you very much. I see that there are still, well, I'm aware of the time, but I see that there are still 2 questions in the audience. Okay. Yeah, maybe we'll take both questions and then we'll give each speaker a minute or 2 to reply. The lady at the back and then the gentleman in front here. We'll take both questions and then final remarks by our speakers.
Yeah, thank you for taking the question. I'm Eva from the Consulate General of Belgium. I have one remark and one question. The remark is about the immigration discussion. I think it's quite astonishing because all the speakers keep on repeating that Hong Kong is a very special place, which I very much agree to. And one of the things that makes Hong Kong such a special place is the fact that people can get through immigration quite fast. And that's what is attractive for foreign companies to be based in Hong Kong, because compared to other countries and other regions, it's way easier to get a work permit. So the fact that just on this case, migration would say no to Timothy Owen would be very weird for me in light of the history of Hong Kong. But that's just a remark. One question is about, as I'm not a legal, I don't have legal background, for me it's not clear whether this new law would only affect cases of national security law or cases related to national security. And let me explain, why I'm confused, because I can imagine that in the future there might be a very big economic case that is of worth a lot of money, where a foreign company who normally have indoor lawyers and law experts, international company might, for example, have a big case of economic value that is so high that is of national security, but not related to national security law. And in those cases, I can imagine that those companies would like to use their in-house lawyers. So would those cases also be affected under the new ordinance, or is it only specifically related to national security law? Thank you.
Maybe I can try to answer that. The amendment is not limited to criminal cases. So you're right in the sense that it's not only prosecution under national security law. It also extends to civil cases or judicial review, where there are cases relating to national security. Now, the problem that you have highlighted, it may not be something that one has to be too concerned about, because there are civil cases that has a national security element. I would say it's inherently very rare, extremely rare. And in any event, one is not talking about the identity of the legal team. I mean, you can have big teams of solicitors, in-house counsel working on the case. It is only to do with the barristers admitted in the court to argue the case. So very often in cases that we handle, although I'm the advocate or Alan is the advocate, we have a big legal team behind us, skilled in the client's business, who are not based in Hong Kong supporting us. So in that regard, I don't see that as a big issue.
Thank you. One last question.
Okay, thank you very much. I'm Jesse. I'm the JD1 student. I want to ask, or I'm wondering, what's the significance or the necessity for the interpretation of this case? As you know, as the statistics showed by Albert Chen, there are only very few cases in Hong Kong for the overseas qualified lawyers presented in Hong Kong's court. So what's the necessity for the CE to submit this case for the explanation from the NPCSA? In fact, the people neither in Hong Kong or in mainland, they are not interested in this case. And especially compared with the former explanations, such as the Wuganing case, which involves billions of people's interest in Hong Kong. So what's the significance of this case? That's the first question. And the second one is that whether or not this can be regarded our slight strategy of interference of the judicial independence in Hong Kong. There was a slam in mainland China, which means, which tells 温水煮青蛙, which means spoiling the frog by the mild water, and the frog was reluctant to resist, but eventually the frog will die. And so, as the professor said that Hong Kong is unique, but how to guarantee the unique of Hong Kong, especially in the common law legal systems? As well as the common sense, the common law systems include the judicial independence and the separation of law, which is the soul of the and core interest of the common law legal systems. But the Beijing government declares that the judicial independence and the separation of law are totally wrong. And this kind of Western error opinions which is supposed to resist. So what if someday in the future that the National Security Committee declares and enforce the judicial revolution for the abolish of the common law systems? What at that time? How should we, the law professions in Hong Kong, to uphold the common law systems and the democracy of Hong Kong? Thank you very much.
Okay, thank you. Would any of our speakers like to have final remarks? Final remarks?
No, I'm just asking to repeat the question.
Oh, okay. Simon, do you have, Simon or Victor, any remarks? Final, yeah.
There are multiple questions.
Yes, I think you answered your own question. You asked what's the significance of this whole episode. And I think the significance is it helps to demonstrate that we do have some autonomy when it comes to national security. They threw the ball back to us, and we had to solve the problem. Government was looking for an answer from the Standing Committee, and the Standing Committee said, well, you guys can figure it out. So that's what we're trying to do now.
Okay, quick comments, yeah.
It seems that the student is worried about judicial independence and about whether the National Security Committee has the power to change Hong Kong's legal system. So my own answer, my own view is that judicial independence means that courts can independently decide cases in accordance with the law. But the courts will have to apply the law as it stands at any particular time. So at the time the Owen case was decided, the courts independently applied the law as it stood at that time to grant the admission of Mr. Owen. But if the law is subsequently changed in accordance with the proposed amendment to the Legal Practitioners Ordinance, the court will just have to apply the new law. If the ordinance imposes a blanket ban on foreign lawyers, which some legislators advocated, which the government has not adopted as an option. But just imagine that even if the ordinance, the amended ordinance provides a blanket ban on foreign lawyers in national security cases, the court will just have to, apply the law. The court will continue to admit foreign lawyers in non-national security cases and will no longer admit lawyers in national security cases. So there's nothing to do with any judicial independence being threatened or prejudiced. As for the National Security Committee, in fact, my own view is that the interpretation doesn't give the National Security Committee any legislative power or judicial power. I think it is mainly a policy-making body on national security. So it's just that the Executive Council is a general policy-making body. The National Security Committee is a specialized policy-making body on matters of national security. So this case illustrates very well that even though the Standing Committee says this National Security Committee can deal with this issue of foreign lawyers in Hong Kong, in the end, the National Security Committee did nothing more than just saying that it would support an amendment to the Legislative Council, to the Legal Practitioners Ordinance. So it will now be up to the Legislative Council to deliberate on the proposed amendment and to decide whether to pass the amendment.
Thank you very much, Albert. Thank you so much for this highly educational session. Please join me in thanking our speakers once again. And our special thanks to Mr. Hu and Mr. Dawes for making time to this session. We know that you have extremely busy schedules. Thank you very much for making time. It's really great to have your insights, and I'm sure the views in this session will inform the legislative process. Thank you for coming. I look forward to seeing you in the next CCPL event.